My name's Gerakiteys. I'm a partner here in the Intellectual Property and Technology team in Sydney, and I'm joined by Monique Azzopardi and Brenton Steenkamp. Monique is a special counsel at Clayton Utz. She's a commercial lawyer with a particular focus on technology projects and transactions. She acts for entities in both the private and public sectors and has specialist expertise in privacy law, data protection and data access, and is regularly called on by clients to assist in them navigating privacy legislation. Brenton is also a partner here in Sydney and leads the firm's cyber and data governance offering with a focus on proactive and reactive cybersecurity and data governance services. He advises and assists clients across the life cycle of cyber response and remediation, related compliance programs, through to crisis management and high-stakes regulatory investigations. We're also joined by Joel Parsons and Grace Griffiths, two senior associates in the IP team here in Sydney with me. Now, Monique, Brenton and I will be walking you through the suite of reforms, but are conscious that there will likely be a number of questions given the significance of the reforms, so we've allowed plenty of time at the end of the brief presentation for questions. I'll pass over to Monique, who will set the scene by providing a brief overview of the significance of the reforms we're talking about today.
Thank you, Dean. So I think we can all agree that it's been a busy week in Parliament. Of course, the focus of today is on the proposed privacy reforms which were introduced yesterday. The Privacy and Other Legislation Amendment Bill that Mark Dreyfus introduced yesterday represents just the initial tranche of the government's proposed privacy reforms. The Attorney-General has, however, teased that there is more that is yet to come. Ultimately, we think that a true overall assessment of the reforms needs to be looked at collectively and having regard to what the future tranches of the reforms may look like. But for now, we're going to focus on what has been tabled, and there are three key themes with these particular set of privacy reforms. Firstly, the reforms target the digital environment. We have the new proposed anti-doxing laws, the introduction of new requirements in relation to computer automated decision making, and reforms that target children's privacy in the online environment. The reforms have been said to complement other government initiatives and reforms, including the cyberbullying scheme and the takedown powers of the e-Safety Commissioner. Secondly, and another core theme with the reforms, is the target of antisocial behaviours, serious abuses of privacy through the introduction of a tort for serious invasions of privacy. We again have the anti-doxing laws, which target the release of personal information in a manner that is menacing or harassing. And thirdly, the reforms signal a tougher approach to privacy protection and enhance the enforcement powers of the Minister, the Information Commissioner and the courts. The laws, of course, now criminalise certain doxing activities and impose new civil penalty provisions. These privacy provisions are obviously, and these reforms are obviously very interesting to us as lawyers, but they're equally of interest to us as people. At a personal and individual level, we will gain increased privacy protections due to these reforms, but we will also be subject to some of these reforms. Privacy compliance is no longer only for big businesses, and on that note, I'll hand over to back to my colleague Dean, who will take you through the new tort.
Now, if it would assist, we can actually circulate the slides to the group after the event, so you've got the relevant background history that Monique touched upon, but also what we'll come to insofar as the various things we're going to focus on. Now, certainly as a litigator, maybe it's a bit sad that I'm the one that's really excited about the statutory tort, but what we're talking about here is one of the most significant reforms in the privacy landscape, which has been mooted for a significant period of time. As the Attorney-General noted in his second reading speech, discourse on giving individuals the right to take action for invasions of privacy is not new and is certainly not confined to the digital age. That said, until now there has been no specific law in Australia that lets an individual sue for invasions of their privacy. The High Court thought the time was ripe as far back as 2001, and the ALRC suggested introducing a law as far back as 10 years ago in its 2014 report to fill what was even then a significant gap in the Australian landscape, notwithstanding we're at the infancy of really what has become the digital age. Yesterday's bill delivers on those promises by creating a legal right for people who have had their privacy seriously invaded. Now, importantly, the tort exists outside of the Privacy Act, and so not only relates to information, that is, it doesn't just relate to personal information, but it also includes protections against physical intrusion. Now, the elements of the statutory tort are set out on the slide, and we'll step through a few of them in a bit more detail, given where this all appears to be heading. Now, as a start, it's important to note that the invasion of privacy must be one or both of the following. That is, intrusion into seclusion or misuse of information that relates to the plaintiff. Now, an intrusion into seclusion would include activities like surveillance, whereas misuse of information is intended to cover a wider range of activities, including but not limited to invasions of privacy by collecting, using and disclosing information. In the EM, storing, interfering and or modifying information are also said to be ways in which information might be misused, as is maliciously releasing an individual's information online without their consent. Now, Monique will talk more about the criminalisation of doxing, but certainly what's now available to plaintiffs is an ability to seek civil remedies in the event of doxing as well. Now, not every invasion of privacy will be actionable, and that's not itself a surprise. A claimant will need to show they had a reasonable expectation of privacy in all the circumstances, and there are a broad range of factors set out in the bill that are relevant, including, for example, the way in which the invasion occurs, its purpose, and the attributes and conduct of the plaintiff. Where the invasion relates to misuse of information, relevant factors will also include the nature of the information, how it was held, and whether it was already, for example, in the public domain. Importantly, as to the threshold, negligence will not be enough to establish the cause of action, and the invasion must be serious. A claimant will therefore need to be able to show that the invasion was committed intentionally or recklessly, and recklessness is itself a higher bar than negligence. It's also one that you don't ordinarily find in a tortious context, and so because it's not a concept ordinarily used in tort law, it's to be given the same meaning as in the Commonwealth Criminal Code. That is, where a person is aware of a substantial risk, and having regard to the circumstances known to them, it's unjustifiable for the person to take that risk. Now, the fact that only serious invasions are covered is intended to guard against trivial claims, and what is to be considered serious is assessed objectively, though there are a number of factors to which a court might have regard in the proposed legislation when assessing the invasion. That list, while not exhaustive, includes the degree of offence, distress or harm to dignity that the invasion of the privacy is likely to cause. The knowledge and motive of the defendant are also relevant, so a malicious act, for example, is more likely to be considered to be serious. Now, where the invasion involves issues of public interest, then there is a recognition that a balancing act is required, and that is, a court will need to be satisfied that the public interest in protecting the claimant's privacy outweighs the public interest sought to be relied upon by the defendant, which includes but is not limited to things like freedom of expression, freedom of the media, proper administration of government, open justice, national security and other like issues. There are also a number of notable exemptions included in the bill, namely for enforcement bodies, intelligence agencies, children under 18, and I'm sure what is welcome to everyone in the room, journalistic exemptions. I will focus on the journalistic exemption because that has been the subject of a number of discussions over the years where the tort has been talked about. And that exemption will apply where the invasion involves the collection, preparation for publication, or publication of journalistic material. Now, journalistic material is broadly defined to mean material that has the character of news, current affairs, or a documentary, or is material that consists of commentary, opinion, or analysis about these kinds of material. So they are quite broadly framed. Now, in terms of what a successful plaintiff could expect to receive in the event of making good on a claim, the available remedies include all of the usual suspects, namely interim and permanent injunctions, damages including for emotional distress, as well as exemplary or punitive damages in exceptional circumstances. Note, however, there is a cap in the bill of $478,550, and that is the current cap for damages available under defamation law. The intent behind tying the two together is to ensure equal protection to privacy and reputational interest, and to discourage plaintiffs who might have both causes of action available to them to simply elect between the one that has the higher cap. So we'll allow questions at the end in relation to the tort, but I'll pass back to Monique in relation to the other reforms.
Thank you.
Pass you the clicker.
Please proceed with the lunch while we
Okay, so I'll now touch on anti-doxing, and I know there has been a lot of reports already in the media in respect of this particular reform. So in March this year, the Australian government sought the public's sort of feedback and response and views on doxing. And the submissions that were provided by the public in response of that are available, are publicly available. And it is kind of, for those that are interested, worth kind of perusing some of those submissions. So those submissions are, in part, I think, informed the amendments that we saw yesterday. So the bill, in a nutshell, proposes to criminalise doxing, the release of an individual's personal data using a carriage service that is menacing or harassing towards the individual or a group. In touching on these reforms, we do think it's helpful to contextualise them. So the government has identified that there has been an increased use of online platforms through practices such as doxing, and that such practices can constitute a form of abuse. The reforms do also, of course, come in the wake of reports that the personal data of hundreds of Jewish creatives and academics who were members of a WhatsApp group had been leaked online earlier this year. Doxing has also been used, reportedly, in domestic violence situations. And so let's go through the elements of the two new offences. So on the slide, we've got sort of the key elements spelt out. So firstly, it's the use of a carriage service, for example, the internet, to make available, publish, or otherwise distribute personal data of one or more individuals. So the bill does spell out what personal data is. Effectively, it means information that enables the individual to be identified, contacted, or located, and it includes, without limitation, information such as the name, telephone, email address. It also includes a person's photo or their image. It also includes information, for example, about the person's place of worship or their workplace. That list, of course, is not exhaustive. And so the first element of the offence requires that the person makes available, publishes, or otherwise distributes that information. The explanatory memorandum to the bill provides some additional context as to what this may mean in practice. It has stated that concepts of making available, publishing, and otherwise distributing information are intended to capture a wide range of ways in which a person may circulate or cause to be circulated personal data. It goes on to say that the act of publishing information includes publication to the public at large or potentially only to a section of the public. This could be through a blog, through social media, but it could also be through a private, online forum. The explanatory memorandum also notes that it is immaterial to the concept of publishing information whether a person has actually viewed the information. So the next key aspect is that the contact has to be engaged in a way that a reasonable person. So that effectively injects what we kind of know in the legal circles as an objective test, a reasonable test as to whether or not it would, in the circumstances, comprise that menacing or harassing behaviour. And that objective test is sort of picking up, so it's not subjective. It sort of brings into play, I suppose, community standards or sort of common sense in respect of these particular types of activities. Now, of course, it's not menacing and harassing. There's two different. It can either be menacing or harassing. Now, menacing, obviously, of course, it's that sort of element of, evil, really sort of bad behaviour that is targeted at a particular individual. What potentially the term harassing means, we'd be interested to see how that is eventually interpreted, including in the context of sort of other laws. The other, of course, aspect of the reform is that it makes a distinction between two types of offences. So the first offence is targeted at one or more individuals. So for that first offence, that carries a potential term of imprisonment for 6 years. Now, where the offence is targeted to specific groups, so where the conduct is engaged in whole or in part because of the person's belief that the group is distinguished by race, religion, sex, sexual orientation, gender identity, intersex status, disability, nationality, or national or ethnic origin. So that's sort of the unique element of that offence. And in addition, for that second offence, there also is that reasonable sort of person objective test. And again, it has to be either menacing or harassing. It's immaterial whether the group is actually distinguished by the relevant personal attributes. It is the belief of the offender that is the relevant factor. And the explanatory memorandum also reinforces that the motivation, it doesn't have to be the sole motivation. There may be a range of reasons as to why an individual has engaged in these particular activities, provided that at least one of those sort of meets that second limb, that will sort of meet the grounds of the offence, subject to satisfying the other aspects. It has been, I think it's been a little bit one of the reforms where I think there's been groups of people that have welcomed these reforms, but I think there has also been groups of people that have showed, I think, some degree of concern potentially about the fact that this is now a criminal offence. The penalties are sort of hefty. The explanatory memorandum to the bill in respect of the penalties did note that the maximum penalties of imprisonment, and these are maximum, has been set at a level that the government considers is proportionate and adequate to deter and punish the damaging behaviour of doxing, and to reflect the wide-ranging serious harms and impacts on individuals, which can be physical, psychological or financial in nature. The higher sort of penalty for that second character offence, where you're targeting a particular group, it's an additional year in recognition of the fact that there are, additional obviously harms when particular groups are targeted, for example, because of their religion or because of their race. Now, the fact that it is that objective test, the fact that you do need to meet, it has to be menacing or harassing, those are supposed to confine the offence, but of course it will be interested to see how this is interpreted by the courts if these laws get passed, and also how these particular laws will interact with existing laws that are in the criminal code. And it is worth noting on that is that this isn't an amendment to the Privacy Act. It is an amendment that will be introduced, if passed, into the Criminal Code Act. I'll just move on to thanks, Dean. So just to take you through another sort of key reform is in respect of children's privacy and the introduction of a online sort of privacy code. So that the bill does recognise that, you know, children are particularly vulnerable to harm, and especially in the context of the online environment. Now, interestingly, in the government's response to the Privacy Act review at the end of last year, which is about sort of 12 months ago now, the government did agree in principle to a suite of proposed amendments to apply specifically to children. Now, not all of those reforms were, of course, canvassed yesterday, but one of the key things that was this proposed code. And so what the reforms will require is that the Information Commissioner has to develop a children's online privacy code about online privacy for children. Now, the code, once it's developed, has to be complied with by entities that are subject to the Privacy Act. In circumstances where they provide social media or other online services, and that service is likely, subject to a couple of exceptions, is likely to be accessed by children. But the bill does flag that there may be some exceptions to that which would be potentially articulated in the code. So it's very much a wait and see potentially what any such code may look like if the reforms are passed. Interestingly, the reforms don't expressly include provisions around age verification. However, it may well be that that is addressed in the code. Interestingly, in relation to the code, the Information Commissioner will be required to publish that code and make it a draft of it and make it publicly available for comment. And the Information Commissioner also has to consult with the E-Safety Commissioner and the National Children's Commissioner in respect of the development of that code. The reforms did actually confirm, and this was sort of foreshadowed in the government's response to the privacy reforms, that certainly for the purpose of the code and these specific amendments, that a child does mean an individual who has not reached 18 years. Of course, that particular measure may not apply in respect of maybe future reforms. Obviously, this week the government also announced a proposed age limits in respect of the age of which a child can sort of access certain social media platforms, and sort of various different, I think, ages have sort of been talked about. So it'd be interesting to see how, if the government does do those reforms, how they interact with these reforms. So very much a sort of wait and see approach there. Go to the next slide. Another sort of key aspect of the reforms is around automated decision making. I think there's been a lot of sort of public concern around the use of automated decision making in various different contexts. This particular reform, though, is targeted on the transparency of the use of automated decision making, so where computer programs are using automated decision making and a person's personal information is involved in those processes. So entities that are subject to the Privacy Act will need to disclose in their privacy policies that where they do use automated decision making, and it does sort of meet the test that's on the screen, they have to make that transparent in the privacy policy. So it's very much around making it transparent around the uses of, you know, more emerging technologies. The government had also flagged at the end of last year increased sort of transparency more broadly around privacy policies. Those specific reforms have not been injected at this stage, so it would be interesting to see if they're part of the next batch of reforms. There are, of course, other reforms of note. There are increased powers of the minister, particularly in the context of information sharing, including in the context of emergencies. There are increased controls around the sort of circumstances and sort of compliance with directions in relation to emergencies. There's also the powers of the minister to direct or approve the Information Commissioner to conduct public inquiries. There's new enforcement powers a number of additional Information Commissioner powers. There are also powers in respect of the courts to make various different orders. What I certainly found of interest is the new civil penalty provision. So an entity can now potentially be subject to a civil penalty for breaches or non-compliance with some of the Australian privacy principles. And for those that are not familiar with it, Australian law, it's a little bit different to the EU GDPR, is very much principles-based legislation. It is underpinned by a set of Australian privacy principles, and failure to comply with some types of those principles, for example, if an entity fails to have a privacy policy, could result in civil penalty provisions. So really, I think giving some more teeth to what is there in the Privacy Act to really make it clear to entities that, hey, if you don't do what you're meant to do, that there are penalties. And of course, that comes off the back of the reforms at the end of last year in terms of increasing the sort of penalties that for sort of serious breaches of privacy. There's also greater flexibility for the Information Commissioner to develop temporary APP codes on the direction of the Minister if the Minister is satisfied that it is in the public interest to develop such a code, and the code should be developed urgency. And what this is, I think, intended to pick up on is, you know, technologies in particular are evolving at a rapid pace. It's intended to enable the flexibility to develop codes without necessarily having to go through a full legislative process, which obviously can take some time. So this enables the development of those sort of temporary codes to address those sorts of situations that may arise in the future. The legislation also does sort of clarify and amend some of the Australian privacy principles, and I'll now sort of hand over to my colleague Brenton, who'll take you through one of those in the sort of security and destruction of personal information context.
Thanks, Monique. Yeah, very quickly, just to focus on the privacy principles, as Monique has alluded to. We all know about the breaches we've seen over the last couple of years within the context of Australian businesses, but also abroad. And if you think about, you know, from a cyber breach perspective, a data breach or leakage, data has become that, you know, we've all heard the terminology around the new gold or new oil or whatever it is now. I think, Monique, you referenced the new asbestos type scenario to data. But what this reform brings about is around these privacy principles, particularly on two aspects, is organisations now need to take reasonable steps, what is deemed to be reasonable, particularly around the fronts of the technical and then, more importantly, the organisational type measures. Now, what does that really mean? Now, I think a lot of organisations have embedded a good range of technical processes around controls to embed the necessary security measures to maintain security, particularly you know, where that type of organisation or for its ongoing business function to protect itself against the onslaughts of a cyber attack, or for that matter, just different types of attacks taking place. However, the point around the organisational measures takes it a step further. So I think there's going to be now a deeper sense of responsibility, but also ownership, not only at the governance layer, but also at the operational layer within organisations. So, you know, processes needs to be embedded around the training and the awareness of what does this data mean to you as the user, but also from an institutional perspective, how do you protect that data? Are you using it for the purposes of why it was acquired in the first instance? And if you sum this up in terms of the issue around data breaches, a heightened focus around when the data reaches its full potential in terms of its first requirement in terms of usage, what has been done to either de-identify the information or destroy it accordingly. And this is something that needs to be driven at a more higher level, and the corporate responsibility is going to be heightened in this regard. This will help, obviously, in the long run, a long way to mitigate the issue we all know around not only the cyber attacks, what we see taking place, but more importantly, data leakage. And this all ties into the privacy principles as well, and I think fits into the theme of what this bill is trying to achieve at the end of the day. So in summary, reasonable steps is a wide term, it's a loose term, but I would say that the judge to that would not only be internally but also externally in terms of what does that mean in the eyes of society, and what are we doing personally to safeguard that type of information, but also at the organisational level, what has been done to actually manage it accordingly and to follow good governance around the actual data holdings. I think that covers the main points I wanted to bring forth. Now, just as a last point, I think large organisations, multinationals, have probably done a lot in this regard, but more can be said around the medium to small enterprises. What are they doing in regards to that second point around the organisational measures? So I think there's a lot of homework still to be done in that regard. And back to you, Dean or Monique?
Just very briefly. Can you move to the next slide for me? Thank you. Okay, so obviously this is just the initial tranche of the reforms. I've sort of got a quote from the Attorney General there on the screen. He did expressly foreshadow, sort of at the end of his second reading speech yesterday, that the government is in the process of sort of in the coming months developing the next tranche of the reforms. As to what they will look like, I think it's always difficult to sort of crystal ball gaze. Obviously, we have as a general indication the government's response to the privacy reforms that was published in September last year. Some of those could potentially be picked up. Something that we've identified here is that I think there was a sense that potentially Australia might move a little bit closer to the EU GDPR model, moving away from those more principle-based privacy compliance. But the fact that the government has specifically amended some of the Australian privacy principles, I think perhaps gives a hint that there may be, that the principles are here to stay, but they may potentially be amended. I think what will be of most interest is how the exceptions for small businesses, employee records exception is dealt with, and whether or not that is picked up in the next tranche of the reforms. And I think, as I sort of started with, we do need to kind of look at these as a collective whole to kind of see, how they sort of all interact with one another.